Good afternoon, everyone, and welcome to the seminar on the concept and the role of courts in family and succession matters. It's a great honor for me to chair this webinar. It is inevitable that law has to respond to new developments. Everyone will know that most EU private law instruments presuppose that justice in the area of family and succession law is still mainly administered by courts. However, it is a current trend in the member states and also in third states to shift matters from courts to other authorities such as notaries, civil status officers, advocates, or even the private parties themselves. There's a new word for this development, de-judicialization. I wonder if I'm able to pronounce this complicated word correctly. Private international law and civil procedure law have to cope with this development. We have to ask ourselves the question, under which conditions and to what extent the regime of judicial activities may be applied to non-judicial ones. In other words, which out-of-court activities should be subject to the same regime as the corresponding judicial activities, for instance, in matters of jurisdiction, recognition, lease pendants, and the determination of the applicable law. How far should, for instance, recognition rules be applicable to non-judicial acts? About 10 months ago, the German Bundesgerichtshof raised a preliminary question asking whether a divorce agreement signed by the spouses in front of an Italian civil status officer constitutes a decision according to the Brussels 2 bis regulation. What the objective of this ELI project is to develop an outline for an harmonized European concept of courts and the application of the same regime for decisions and comparable non-judicial instruments. Enough from me. We have a very, very interesting panel with at least one of the rapporteurs. François will join us perhaps later. Elena and Veronique and Andreas are here to bring external perspectives. The rule of the game is 10 minutes for each panelist, and then we'll have a Q&A session afterwards. So without ado, let me pass over to Elena, who is a professor at the University of Pisa, and she's well known throughout Europe in the field of private law and family law. Elena, the floor is yours.
Yes, I have a PowerPoint presentation. Thank you very much, Matthias, and welcome everyone. My task today, as one of the reporters of this project, is to present the report in general, its background, the questions it involves, its aims, and its still provisional results. I'll speak today also on behalf of the other reporters, Anatol Dutta, who cannot be present here today, and François Tremosa, who will join us hopefully in a while. I must underline first that the report is a very preliminary, still a very preliminary draft, aimed to raise the awareness of the questions we are dealing with and to stimulate the widest possible debate. Second slide. The starting point of the project, I don't know whether okay, yes. The starting point of the project is the judicialization trend, as Matthias has anticipated. That is the increasing shift in the administration of justice from judicial authorities to other different public and private sectors. In particular, in the field of succession law, and more specifically regarding the competence to issue certificates of succession the competence of notaries, at least in the Romanistic legal systems, is of course traditional, and therefore there are several systems awarding the notaries the competence to issue both the national and European certificates of succession. There are, on the other side, systems which reserve the competence, still reserve the competence to issue both certificates to the judiciaries, and some systems which are in a way in between. In the field of family law, third slide, in the field of family law, various forms of private divorces have been introduced across Europe over the last 20 years. However, which non-judicial authority and how the shift of judicial competences has taken place vary considerably at national level. Again, there are member states where notaries are competent to issue consensual divorces. There are systems where administrative authorities and or lawyers combined with different public authorities are involved, and again systems which still believe that judicial competencies cannot be delegated in such matters. Of course, these national developments challenge the concepts of court and decision in EU international private law, which traditionally relies on the formal concept of court and decision, as the Advocate General on the occasion of the Saihuni case emphasized. This is the fifth slide. This is an overview of the definitions of court in the current regulations on family and succession law, where one can notice that the definitions vary. Even the oldest regulation upholds comprehensive definitions, but only the latest ones deal with or address the general question of judicialization. As regards the developments in the case law of the Court of Justice 6, yes, of course the court has developed an autonomous concept of court, whose meaning, nevertheless, oscillates between a formal and a functional approach according to the different contexts. Even in the realm, this is the seventh slide, even within the realm of family and succession law, the definitions of courts and their role vary. In family law, for instance, both cases, so far, one of which is still pending, focus on the sphere of application of the regulations involved, Rome 3 and Brussels 2A, and the main question in both cases is whether a decision should be an act having a constitutive effect. In the realm of succession law, number 8, in the realm of succession law, the issue of definition of court has come into play to determine whether a national notary was bound by the jurisdictional provisions of the succession regulation and was able, in another case, to produce a decision. The latest case, which is still pending, is the most innovative one, as it raises the issue whether a Polish notary is allowed to submit a preliminary reference according to Article 267 of the Treaty on the Functioning of the European Union. Against this background, number 9, against this background, the report addresses, and the project in general addresses several questions, which are summarized in a questionnaire we have circulated. And the project and in general follows a functional approach to the concept of cause, emphasizing the circumstance whether the non-judicial authority is allowed or not to produce the same effect as the corresponding judicial act, regardless of whether it is allowed to resolve legal disputes and the proceeding is contentious or non-contentious. The effects have a constitutive or declaratory nature. As regards the principles in detail, one of the most controversial, for sure, number 11, is the one on jurisdiction. The one on jurisdiction, which addresses the question whether the aim of seeking to avoid the giving of irreconcilable decisions in different member states, this is a citation from Oberle, the Oberle case, prevail on that of respecting the different systems for dealing with matters of succession applied in the member states, according to the recital 20 of the succession regulation. The second principle on minimum standards addresses the question whether the EU should set minimum standards for delegating tasks from judicial authorities to other public or private actors, and more specifically focuses on the effectiveness of the child's fundamental right to be heard even in non-judicial proceedings. The third principle about circulation addresses the question whether there should be a duty to recognize authentic instruments or registered declarations by other member states. And finally, the fourth, which is more limited on applicable law on divorce, addresses the question whether the term divorce should be given the same meaning in Rome 3 and Brussels 2B, as underlined, emphasized in the Saihuni decision, or whether the respective scopes should diverge. I hope this is my time has elapsed, and I hope I have given at least an insight of the questions we are dealing with. And I am very much looking forward to receiving your feedback, and I thank you very much for your attention.
Thank you so much, Elena, for this concise overview of the aims of the project and the discussions. And now welcome François, who will give us an overview concerning recognition and enforcement.
Yeah, and jurisdiction, first of all, because this is one of the most debated and controversial.
Okay. Thank you.
Yeah, can you hear me? Yes, I think so. Okay, good afternoon, everyone. Sorry for the slight delay. I will indeed raise the issue of out of court.
Sorry to interrupt you, François. We can hardly hear you at the.
And I will start by an example in the context of the succession regulation to, I don't know why my audio.
Sorry, Francois. Might be we wait for a moment. It's practically impossible to understand you. Okay. I just hear from the Eli Secretariat that Francois will try to join again. Might be Elena. Might be in the meantime, Elena could tell us some words about the discussions concerning jurisdiction. Elena, you're still muted.
Okay, may I be allowed to share my screen, because I have some slides which are helpful to present the illustrations of the principle on jurisdiction, which are illustrations which are based on the discussion I had with Francois. So I hope okay. Yes. Can you see the slides? Yes. Okay. Yeah, the principle of jurisdiction, as I have anticipated, is one of the most controversial, even between the reporters. The principle states that family and succession acts are reserved, to the judiciaries in some member states, can only be performed in a member state whose courts have jurisdiction for the matter under the relevant EU rules on jurisdiction. It adds that the lack of jurisdiction is a ground to refuse the recognition of any authentic instrumental agreement drawn up or registered in the member state of origin. We have provided an illustration of which maybe is able to make clear the practical implications of this principle. A French citizen away in Germany, where she or he had his or her habitual residence. He or he leaves assets located in France, except for a bank account in Germany, where she or he received his salary. The current solution, according to the existing succession regulation, is that the competent German court is, of course, able to issue both a European certificate of succession and or national certificate of succession. However, a French notary, if asked by the heirs, might issue a national certificate of succession as well, as according to the current regulation, he or she is not bound by the rules on jurisdiction established by the regulation. Therefore, if the heirs ask the French notary to do so, two potential conflicting certificates might be issued. The solution would be different according to principle 1, because the French notary would not be allowed to issue the national certificate of succession, as French courts would have no for sure jurisdiction according to the succession regulation. Consequently, if the notary issued the certificate, the recognition of this certificate might be refused. As I anticipated, this principle addresses a fundamental issue, which is whether the EU, which way the EU should follow, whether a way which is in the line of a harder harmonization, or rather in line with the respect of national traditions. An opposite illustration is about a German citizen. The example is the opposite of the previous one. A German citizen passed away in France, where he had his habitual residence. However, she or he leaves assets located in Germany, except for a bank account in France, where he or she received the salary. According to the current regulation, the French authority can issue both the European certificate of succession, national certificate of succession. If, however, the heir sees a notary in Germany, she or he will not be allowed to issue any certificate, as German courts are bound by the rules on jurisdiction. The solution, according to principle 1, would be the same in this case, because there is no conflict between different certificates. I hope I have illustrated the practical implications, and as I said, I'm very much looking forward to receiving feedback, inputs, and so on and so forth. Thank you very much.
Oh, thank you, Elena. That's really a very difficult question. I wonder if you come to reach common ground one time. Okay, François has joined us again. François, we have now the topic of recognition, and
or if you want to add, maybe François would like to add something on jurisdiction, because
yeah, but he has left us
as notary, especially because he is a notary.
He told me on the chat that he thinks that his connection is too weak.
Okay.
May I try to ask Elena again if she could give some words on?
Well, I have to come back to my previous slides. Maybe it's the other principles are bit less controversial, but
might be in the meantime, we could have another try.
Yeah.
To
so
make connection with François.
Yeah.
François, I wonder what you heard about what Elena is.
Yes. Well, I don't hear me properly or not. Can you hear me?
Yes.
Yes.
Okay. Yeah, I'm sorry. I have definitely connection issues. I think Elena presented the case of the French and the German citizens. Can you understand? Yeah, okay.
Yeah.
And the point of that case was really to have the opinion of the audience about how should we act on this asymmetry. How can, in some countries, notaries be able to deliver a national certificate, whichever the circumstances are, and in other countries, the courts who have the sole competence to deliver either a national certificate or an ECS are bound by the rules on jurisdiction. How should we deal with this asymmetry? Should we state that even when the authority that delivers the national certificate is not a court, should that authority be bound by the rules on jurisdiction or not? That's not the case today under the session regulation. Or shall we leave things as it is? Because of course, there are reasons why the succession regulation was set up this way. And lastly, shall we state that authentic instruments should be fully recognized in all European Union countries, member states, and not in the succession regulation? And I'm very much looking forward to hear the audience and the opinion of the audience on that point.
Okay, thank you, Francois. And what concerns recognition and enforcement, is there something to say from your side?
I haven't prepared anything on that regard, so I think it's better that Elena presents that point, because I really prepared only the jurisdiction point.
Okay, thank you. So might be we have a few minutes for Elena left for the recognition and enforcement topic.
Yes, I'm. Do you hear me? Yes. I share my screen again to show the principles. May I ask the Secretariat to allow me to share my screen? Yes, thank you. Yes. So, yeah, the other principles more or less consolidate general trends which can be deducted from the or seen or underlying principles which are present in the current EU instruments. So, for instance, circulation, which is recognition, but melius re perpensa, I thought that the term circulation might be better used to designate authentic instruments and agreements rather than recognition. This is a very general, still very provisional principle, simply which consolidates and generalize rules which are present in the current in the current regulations. And again, the principle on applicable law, or its formulation, is quite in line with what the court said in the famous Saihuni case, although it might be controversial whether the term divorce should be used in the same meaning in for different contexts, which is the applicable law or the circulation of decision or authentic instruments. So this is exactly the question which is underlying this principle. Thank you very much.
Thank you, Eleanor, for this quick overlook. And now to the external perspective, I want to pass over to Veronique. She's in a tremendous position to give us an inside point of view as a family law practitioner. She's been a lawyer in Paris since 1984, if I remember correctly, and she's a well-known specialist in international family law. Veronique, the floor is yours.
Okay. First, I would like to come back to Elena's first slide, because you say that divorce, out-of-court divorce, are divorce performed by notaries. I am very sorry, but this is untrue, because it is an act of avocat, and it is only registered at a notary. And this has a very big importance, because I'm not saying it's good or bad, but French avocats are pushing through to see their acts being recognized and having a strength that is close to the notary, which is not the case. But anyway, it is an act of avocat only registered at a notary, and the notary has only a duty of formal verification. But this poses problem of applicable law, because there is no duty of the notary to check if the applicable law is applied. And the only case where this kind of out-of-court divorce may go back to court is that is the children ask to be heard. But which child is going to ruin the divorce of his parents, amicably settled out of court, asking to be heard? So I think there's a hiccup in this divorce, because you cannot bring it to court. You have to do it via avocat. This is my first point. My second point regarding the role in French court in succession matters is that mainly in France, courts have a minimum role, except if things goes wrong. But a normal succession will be done by notary in France, and the court has a kind of secondary role if anything goes wrong, if we have to manage the estate and the heir don't agree on the management of the estate, and it's coherent with the regulation of the European regulation on 650/2012, because as Elena pointed out, the French notary has only the right to issue the certificate of succession if he has jurisdiction. Problem is, I'm not sure that all the notaries in France have a good background in international law. Let me say that in France, there's very little lawyers with a knowledge in international family law. And sometimes we are asked to perform a divorce out of court where the divorce out of court cannot be recognized. For example, Kenya does not recognize out of court divorce. So it's a problem, because if the marriage has been registered in Kenya, you're not divorced in Kenya. And there's a lot of divorces being done in France that will not, it's not a problem of EU now, it's a problem of the remaining states out of the EU, and it's a real problem because it's not as simple as it seems. So basically the French court has nothing to do with the registration of a will that is completely done by the notary, and is only being asked, the opening of the succession is not also the duty of the court. It is it's only when there's a measure of protection is to be asked by enforcement of the Article 1305 of the Civil Procedure Code. You must apply to the Tribunal Judiciaire, as you may know, as replace the Tribunal de Grande Instance, which is basically a high court, if I understand well, or managing the estate, and the set of intervention of the French judge is very, very limited. Also, that when there's a refusal of delivery of the assets, the judge, and also one has to know that the criminal judge can interfere, because there is a special, when you hide the fact that there is a heir that has not been given his share and that the notary was not receiving the proper information. This leads to criminal intervention, criminal judge intervention. My biggest fear when I look at the out of court thing is that I think that the judge was everyone has a right to go to a judge, but if you look at it, actually, it's less and less the case, because in many cases, you are asked to go into mediation first, but you can't refuse mediation. If you refuse mediation, in some pilot cities in France, pilot jurisdiction, you're not allowed to have a hearing. So first you go to mediation. Then if you do this out of court divorce, in many cases, you're not receiving the proper information about international law. It's not a problem between two French people who intend to remain in France. But what happens if that you divorce two people with another lawyer and then they move to Kenya, for example? They're not divorced. And this is a problem that I see more and more, that people end up with a divorce that cannot be recognized. In some states of United States, the out-of-court divorce is not domesticated. It's not possible. So the only issue, for example, is to have an out-of-court agreement, at least for the children, that you register in court, so you have an order, and the order is protected by the 1996 Convention and the 1980 Convention. But if you don't do that, you may end up in a catch-and-forth situation where the spouses won't have any documents protecting them. And this is something that our backbencher didn't see when they voted this law. They said first, oh, everybody will recognize this divorce. It's not true. And this is a real problem. And I fear that the trend of the EU to favor more and more out-of-court, easily accessible out-of-court is not presenting the guarantee of stability and circulation that the EU was pretending to give. So this is I'm not an intellectual, I'm not a teacher in law, I'm just a practitioner with my 2 feet in the ground. And I can see more and more problems with out-of-court agreement, even registered, that cannot circulate and that does not give the citizen the guarantee of stability of the situation if they travel. And in the same time, everybody says, you need to circulate in the world. Okay. But what do you do if your order is not recognized?
Oh, thank you very much for these remarks, especially concerning the dangers of these new instruments. Although I do not know whether it is the European Union or is it the national states who are more in favor of these authentic instruments. But we'll get, I'm sure, an inside view of Andreas Stein.
And just add one point.
Yes.
I think obviously the states want to favor out of court because they want to wash up the family from the court, clearly. But in the second time, I think the EU has a responsibility to face strict limits and defend the rights of the European citizen to have a guarantee of stability of their situation if they travel.
Yeah.
It's a philosophical question, by the way.
No, it's one of the main questions. Okay, Andreas, he was a judge in Germany, and he joined the European Commission 20 years ago, and now he is head of unit civil justice there. He will give us an inside view from the European Commission. The floor is yours, Andreas.
Yes, thank you very much, and good afternoon to everyone. Thanks for having me on this panel, and I think we can already see from the discussion and from the statements and the presentations we've heard, that this indeed is a highly relevant and quite fascinating, intellectually challenging, but also practically relevant topic. So I'm very happy about the European Law Institute having taken this up. And I'm very much looking forward to the outcomes of this project. What I will try to do in the shortness of time that's available to me is to give you a bit of an insight, not from a practitioner of law as Veronique is, sort of on the ground in the court or with non-judicial actors, but from a practitioner in terms of drafting and negotiating acts of EU legislation. And in doing that, I ask for your forgiveness on the fact that I will not limit this to only family law issues, because this is clearly the focus of what this project is about. But when we look at the topics of legal certainty and consistency, and those are two of the main sort of themes that I would like to emphasize, we also have to look at the acquis in its entirety, including the civil, commercial, non-family side, where, of course, when you look at the definition of courts and authentic instruments, we have case law there as well on what a court is, the whole Pula parking case law, the Schlump case law, which was also mentioned in the paper, and where we have a very old system of basically just saying authentic instruments circulate under a very generous regime, ordre public being the only ground for refusal. And so if you compare that with the regime in the family law instruments, you see stark differences there as well. So I would ask to basically take the comprehensive picture into account, even when focusing on family law instruments. When I say we look for consistency, then I think my colleagues and myself, whenever we deal with a new project, of course, we do take a look at, how has this been dealt with recently? Is there any compelling policy reason to define a court, for example, differently for succession purposes than for divorce purposes or maintenance purposes? And where we don't think that's the case, we really try to keep a consistent line. You see from the wording and the table that Elena has presented on the different definitions that we haven't been extremely successful in having sort of a uniform definition of what a court is. But I'll come back to that in a second. But I think what I want to say is that, in our quest for consistency and uniformity to the extent possible, because it's also difficult for legal practitioners, for judges, to have a different definition of a court when they're looking at succession, when they're looking at a divorce, when they're looking at maintenance, when they're looking at a normal commercial civil law case. Of course, we always have to ask the question, is there a specific compelling reason for successions to do it differently, or for divorces to do it differently? So we have to look for consistency to the extent that is possible and that's attainable. Now, the last example in which we had to confront this question was obviously the Brussels 2B regulation, where, and here I will try to respond to something that has been said before about the interests of member states and the interests of the Union. It was very interesting that, of course, on Brussels 2B, where you need unanimity to adopt a new act, it was very clear from the start that some member states that have introduced extrajudicial divorces, like France and Italy, wanted certainty that those will circulate under the new Brussels 2B regulation, and they could have vetoed any amendment, any new regulation, if that concern hadn't been met. Of course, the other member states that don't know extrajudicial divorces and are sometimes skeptical, also each single one of them could have brought this to a halt by saying, no, we don't agree to this. And you have the Commission as a broker in the middle, trying to preserve certain principles that we think are essential to uphold. And what you see at the end of the process is the slightly complex solution that we have, which now clearly admits agreements that are registered, such as the French extrajudicial divorce for circulation, and that was disputed before. Of course, some did argue that those extrajudicial divorces were already covered under Brussels 2A regulation. The preliminary ruling referred by the German Supreme Court asks the question about this being a decision. This is about the Italian extrajudicial divorce, but the bigger argument was as to whether this could be covered as an agreement under Article 46 of the Brussels 2A regulation, where there was the interesting argument that such agreements did qualify for circulation, but according to the wording of Article 46, on the condition that they are enforceable in the member state of origin. Now, divorce agreements are by definition not enforceable, and there was an interesting discussion also among member states as to whether this would exclude divorce agreements because they don't meet the standards of Article 46 because they're not enforceable, or whether the condition of enforceability only applies to types of decision that by their nature lend themselves to enforcement in the first place, which is not the case for divorce, so that one could have used Article 46 of Brussels 2A already for agreements. So that was the starting position, and I think the final outcome is to make it clear. So we've achieved the purpose of legal certainty. I think it is now clear that such registered divorce agreements will circulate as agreements under the Brussels 2B regulation and as a counterpart in order to ensure some guarantees. It's always open to discussion whether there are sufficient guarantees. There are some such guarantees, including the jurisdiction requirement, which wasn't there in the first place. So you can have an agreement only in a place that has, where the courts, if they ruled, they would have jurisdiction. The second is there is an emergency break for the issuance of the certificate if there is any indication that the child's best interests may not have been taken into account. And then, of course, there is also the refusal ground in those cases. So it is a compromise solution that tries to balance the interests, and that's what we've ended up in the Brussels 2B regulation. And the next time we have a new project, we will have to ask ourselves the same questions again. I would like to conclude with basically framing the discussion as I see it as two different sets of questions. The first set of questions is, what is a court within the meaning of the EU instruments? And that is the demarcation between the judicial and the non-judicial. And while I see a lot of different definitions and a lot of different texts, I ask myself, and that could be further enlightened maybe by the project, although the wording is different, is there any difference on substance? Because I tend to agree that even with the divergent wordings, there is a common ground in terms of saying we have a functional definition of what the judiciary is. So in order to qualify as a court, you have to exercise a judicial function. That implies the impartiality, the hearing of all parties, and so on and so forth. And if you don't meet these conditions, then you cannot qualify as a court, slightly oversimplifying things. But that's, to me, seems to be the common sort of core of what all EU instruments in this respect have in common. Now, the somewhat more interesting question is, to me, what do we do with the institutions that indisputably are not courts? And in most cases, notaries are not courts. And the succession regulation even says that. Yes, in some cases, when they exercise judicial functions, they may be courts, but in most cases, they aren't courts. So whatever they do can only be an authentic instrument and circulate as an authentic instrument or as an agreement under the Brussels IIb regime. And I think most of the extrajudicial decisions that become more and more popular will not qualify as court decisions under the definitions of the EU instruments. I think at least the vast majority will be something else. They will be authentic instruments, they will be agreements. And the big question here is, what should the requirements be in relation to those indisputably non-judicial types of instruments that circulate under the EU instruments? And here, the obvious questions, and I think that comes up in the jurisdiction question that has been presented by Elena, is if you're not a court, if you're acting as a notary, are you bound by jurisdictional rules, yes or no? And here the succession regulation is very clear. It says if you exercise judicial functions, you are bound by the jurisdiction rules of the succession regulation. If you don't exercise judicial functions as a notary, you're not. Brussels IIb has a different solution. Brussels IIb has now, and Brussels IIb I think is now sort of the state-of-the-art solution in terms of shedding more light on authentic instruments and agreements, because we've dedicated so much attention to this. And the solution found was that essentially those agreements and authentic instruments will circulate only if the jurisdiction requirements that would apply to courts would also be met by whoever registers or draws up the authentic instruments or agreements. So we have a clearly divergent policy solution here. You have the jurisdiction requirements under the Brussels IIb. You don't have them under the successions regulation. And I think that's a very important question going forward. Is the solution that was now identified for Brussels IIb, is that the new model for how we deal with these non-judicial decisions or instruments that circulate? Or are there compelling policy reasons to decide this differently as per each instrument? And also in that respect, I'm very much looking forward to the outcome of the study. Sorry for having overdrawn my time account. And thanks a lot for your attention.
Thank you, Andreas. No problem at all. It was very interesting to see the insight view of the commissioner or person working for the Commission. We have one first question from Ilaria Pretelli. She asks, I quote, my first question deals in particular with the principle of égalité des armes and impartiality. Are public authorities prepared to oversee if private divorce agreements respect the principles? And how can we ensure that respect for this principle has been guaranteed? So might be this question should be answered by Elena.
Yes, this is one of the questions falling under the heading minimum standards, which I anticipated in my slides. I have no answer. Of course, I share the idea that first of all, impartiality should be granted by at least the authorities following or which can be defined as courts. And in a way, the impartiality is also something related to public authorities, for sure, which are not courts, but of course in a different meaning or in a different sense. And the question is exactly whether and how the EU should impose such minimum standards. And if I may, Matthias, regarding this issue, I would like to ask something, if I may, if no other question if there is no other question from the audience.
There is one other question from Ilaria, which if I ask Andreas if he could answer this question. My second question, Ilaria, concerns the introduction of indirect rules of jurisdiction in Brussels IIb. Why not introducing direct rules of jurisdiction also for private divorces?
No, I haven't understood. May you repeat the question?
No, I thought Andreas could answer these questions, perhaps. It's more a political question.
Yes, I would be tempted to answer a counter question, which is something you should never do. But I'm very familiar with the concept of indirect jurisdiction rules from different concepts, like the Hague Convention on Recognition of Judgments that we're just in the process of becoming a party to, where jurisdiction rules aren't harmonized. But of course, when it comes to recognition and enforcement, you do check. I would understand well. I'm processing as I speak, so that's always helpful. If I understand the question correctly, then if now for recognition and enforcement purposes of, let's say, an authentic instrument or a divorce agreement, this will only qualify for circulation if it respects the jurisdiction rules under Brussels IIb that apply to courts. So we have not harmonized. So that means in practice, a French notary could still register a divorce even if he would not have jurisdiction under Brussels IIb. That would just not circulate with other EU member states. But of course, within France, if there is no cross-border element, if there's no need to get this recognized and divorced elsewhere, it would still be a valid divorce. I think this was never discussed in the legislative negotiations, and my guess would be that member states would be very reluctant in order to accept sort of all of their sort of notaries' powers, basically, which, as we have seen from Elena's example, are very different from member state to member state, to basically harmonize them across the board, even in cases where there is no cross-border element, and there will never be a cross-border element. So to build in, let's say, the necessary safeguards for cases in which this actually becomes relevant in terms of cross-border circulation. There is no academic explanation for this. And as I've explained from the Brussels I world, there's no requirement whatsoever. And in successions regulation, we accept whatever member states have done, and that circulates without jurisdiction rules. So tying this to jurisdictional is already an evolutionary step. I think probably tying it to direct jurisdictional rules may have been an evolutionary step too much.
Oh, thank you. We have one remark in the Q&A concerning the UK from Rita Giannini, that under the Family Law Act 1986, an overseas divorce obtained by means of judicial or other proceedings is recognized in the UK only if, and there are some requirements, if it is effective under the law of the country in which it was obtained, and at the relevant date, either party was either habitually resident or domiciled in that country or was a national of that country. And the term judicial or other proceedings requires that there should have been some formal proceedings, either before a court or some other formal body recognized by the state for that purpose. It is an important aspect that the judicial or other body should be impartial as to the outcome of the proceedings. And there is a question following: can a lawyer be considered impartial in a private divorce? So we are in the field of philosophy, might be. I do not know if anybody wants to answer this question.
Veronique would like to answer.
Yeah. Asking a lawyer to be impartial is totally impossible. I mean, the result is two lawyers negotiating with their clients to attain an agreement, but no one is impartial. So obviously for me, the impartiality does not exist. Equality of arms is also a problem, because let me tell you something in France, there's a development of a kind of network of lawyers who advertise for 400 euro, you have a divorce. You know that you should have two different lawyers, and they would give a list of lawyers that used to work together. So basically, where is the impartiality? Where is the equality of arms? If the two lawyers know themselves, most of the time they don't know the rule of jurisdiction, they don't know the applicable law, and they will do a divorce. And Andreas, you said, there is no international element. Yes, but who can say that Mr. and Mrs. Brown, who married in France, were born in France, divorced in France, and then suddenly for one or X reason moved to another country? This happens every day, and there is no security. And this is the problem. Maybe I have a wrong eye, because I always see the things where it doesn't work. Otherwise, they won't come to me. But honestly, I see a danger there. And the equality of arms is clearly not there. We can work on it, but I don't see how we can guarantee that. Maybe Elena has an answer on that.
Thank you very much. No, I have no answer, but I have reflected on this issue. And of course, no, lawyers are not impartial in their essence, of course. But the question, the issue, in my opinion, to think about is a bit different. Let's take the example of a judicial divorce, not contentious judicial divorce, where the court is asked to check, like a notary, not much more than a notary, whether the agreement is valid or any right of the economically weaker spouse is violated, or but let's take let's limit the example only to the relationship between spouses. Is it really a guarantee for the spouses that on the other side of the desk there is a judge instead of a non-judicial authority? Is it so different? I mean, if there is an agreement, if the divorce is based on a consensual, is consensual and based on an agreement which is basically drawn up by or drafted by lawyers and then presented to a judicial authority. This is something I ask.
Okay, Veronique, do you want to add something?
Yeah, I just want to say that the judge has a role to detect the defect of equality of arms, and he does that very well. Even if it's a short time, I think the judge function is to check if the balance has been respected between the rights of the two. And I really feel that when the judge has had to check if the agreement could be made in form of a consent order, he had a very important role. I had hundreds of examples where a judge would refuse because, for example, there was a time where one sole lawyer could represent two spouses for an amicable divorce. So many times I've seen judges I don't know expelled from their office because they found out when they asked the spouse that one spouse has renounced to any financial rights in order to keep her children, or vice versa. So I think the function of the judge is to ensure that. And in the negotiation, as you said, Elena, we are not impartial. And I'm fearing that this equality of arms is going to be armed, and the poor will go to this kind of divorce because they can't afford. It's a little bit like pleading guilty in the United States. You end up pleading guilty even if you're innocent because the risk is too high and you don't have the money to defend yourself. It's a second-class justice, and I'm worried about that. There is a risk. It's not, I'm not saying it's every day. Most of the time it's okay, but there is a risk of second-class justice for the people who can't afford that.
So as a judge, I could resume that the only way out could be to forbid out of court divorces, for instance. No, it was of course an exaggeration. Andreas wants to add something.
Yes, just very briefly. Well, I think the question of how much trust we put in notaries, in other authorities, is clearly a key question, and I think it's legitimate to highlight that you cannot equate a lawyer or a notary with a court. And I mean, the instruments have never done that. There's always that dividing line. But nonetheless, EU law is relatively generous in terms of circulating authentic instruments and agreements, and has always been relatively generous in that respect. I think the change is more not in the system as such, but it's in the use that is being made in member states of extrajudicial proceedings where they couldn't be imagined in earlier days. And you know, I grant you every argument to say equality of arms, we have to see to it that there are sufficient guarantees. Of course, and this is almost a cheap point, but allow me to make it anyway, this is not primarily a concern only for EU instruments. You know, primarily, you know, and I think this is what Matthias alluded to, then we shouldn't have these extrajudicial divorces. That's a question as to the procedure as such. Do we think that extrajudicial procedures, you know, even where they never become cross-border, you know, even within a member state, are acceptable? Because the problems that have been mentioned, you know, of, you know, possible lack of equality of arms, they exist no matter whether this needs to be recognized and enforced in another member state or not. So it goes to the court of, do we think it's admissible to have these things? And I think the only sort of the provisional reply that I can give is that, of course, we've had these discussions under the Brussels IIb regulation, because we've had the member states that wanted to push through the clear recognition of those extrajudicial divorces, and we've had the more conservative, if I may call it that, member states that were very skeptical towards any non-judicial divorce procedure. For example, well, what we've arrived at is, you know, a set of safeguards, you know, that was at least sufficient. And I can only note that as a political fact, that these safeguards were considered sufficient by the member states that do not have extrajudicial divorces, and will be faced with the need to recognize them when they come from abroad. They didn't have to say yes. They said yes under the conditions that were established under the Brussels IIb regulation. And I think I think the trend is there for the moment to delegate more and more to extrajudicial authorities. we will see if problems pop up in that respect, be it domestically or in cross-border situations. And we'll have to see how this plays out in practice. Do we see a higher number of agreements being refused recognition and enforcement on ordre public grounds because, for example, you challenge them and then it comes to light that the best interest of children hasn't been properly taken into account in the procedure, or will these problems not materialize? And I think that's we're in an experimental phase in a way, because we've introduced a novelty in Brussels 2B, and we'll have to see how it works before, in the next recast, X years down the line, we'll have to draw the consequences and see, whether this is something to be maintained, to be tweaked, to be amended.
Yeah, we have a rather pessimistic remark in the Q&A from Sabine Heining. In succession cases, I see now notaries from the Netherlands and France go back to their old system from before 2015. They both grow up in their own country, a Dutch Verklaring and Erfrecht and a French Acte Notarité. Double costs for the client. The ECS is a much better instrument. Okay, I would say we would reach common ground on this. So we are coming to the end. We have 3 minutes left, 2 or 3 minutes left. Do you want to add anything from the panel? Elena, Veronique, Andreas? And I think there are no further questions in the Q&A. So I want
sorry. Yeah, Matthias, just one final remark. As I presented the principle on jurisdiction, I did not point out the difference, the different approach the EU followed in the fields of succession and divorce. This is something which Andreas has emphasized, and the underlying idea is that indeed Brussels should be might be a model for future steps in family succession law.
Yeah, we see it is very complicated. When I became an assessor to this ELI project, I didn't expect that it's so complicated, and we hope that we'll reach really common ground sometime. So I want to thank you all for participating in this webinar. Thank you for all the interesting and useful contributions, and thank you, Elena, Veronique, François, Andreas, for your instructive contributions. And it has been a pleasure for me to chair this seminar. Thank you all, and have a nice evening. Bye.
Thank you. Thank you, Veronique.